Part of the work that General Conference does is legislative. That legislation is in turn both influenced by and influences the legal context as well as the financial impacts of the work of the United Methodist Church worldwide. Today we have three prominent leaders in the area of law, church law, and pensions to help us understand the basic things we all need to know as delegates about our own responsibility and way of thinking about these matters upon which we're voting in terms of how law and law impacting financial decisions are involved. Our presenters today are Pamela Harrow-Liston, who is the president of the United Methodist Church Conference Chancellors Association, and also serves as the chancellor of the North Texas Annual Conference and the presiding judge in Rowlett, Texas. She will be presenting a brief presentation on sort of the fundamental legal issues and how the church is structured to manage those. Brian Mills is with GCFA, currently the interim general counsel for GCFA, and he will be addressing specifically matters relating to the trust clause. And Andrew Hendren is the chief legal and governance officer with Wespath, who will discuss how the work of Wespath has already been involved and will continue to be involved in addressing and providing guidance about the impacts of decisions on pensions and the financial law that governs all of that. Pamela.
Hello, good afternoon. So I am Pam Liston, and I'm from the DFW area, Dallas-Fort Worth area, the home of got some shout outs, that's very nice, the home of actually the area of the 1968 Uniting Conference. So that is really a neat thing to mention at this point. I also want to say that I am the great-granddaughter of an Evangelical United Brethren pastor. And I grew up going to church with my two grandmothers, who were both devout United Methodist, and was raised in the United Methodist Church. So my history here is long, my love for the group and the church is deep, and I'm happy to be with you today. So UMC3 is comprised of the conference chancellors. And I know that I have a few counterparts here in the room. I've seen at least two of you. I'm going to ask any chancellors in the room to stand. If you're a chancellor of an annual conference, please stand. There's the two I've seen. Any others? So we want to thank you for your service. These are my counterparts that are also with me in any legal expertise that I can provide in this context. Thank you for your work. Thank you for joining with me in this important work. Now, I've been given this PowerPoint without any practice. Let's see. How do I forward it? Here? Green button, they say. Oh, that's a pointer. Okay. This one. Thank you. Of course, it's the biggest one. So you are probably familiar that the time of the foundation of the Methodist Church in the United States corresponded in timing with the formation of the United States as a country. It's probably not lost on you that our United Methodist structure very much mirrors the structure of the United States of America. So we have governing church law documents that in many ways parallel the documents of the United States as far as governance of our society. We have in the United Methodist Church the Constitution. We have the Book of Discipline. That's the statutory law counterpart. And we have judicial council decisions, much like we have Supreme Court decisions and other case law that governs us in the United States. Our leadership structure is the Council of Bishops, that's our executive, our General Conference, that's our legislative, and our Judicial Council, which is our judicial. We have our central conferences, and you've heard so much wonderful dialogue and instruction on these central conferences today. We have Africa Central Conferences, Europe Central Conferences, and the Philippines Central Conference, and you can see the subsets of those conferences listed on the screen. We have our jurisdictional conferences here in the United States. You see the North Central and all of the annual conferences that comprise it. The Northeastern, the South Central, the Southeastern, and the Western jurisdiction. This is what it looks like, United Methodist around the world. This is what your General Conference looks like coming together in Minneapolis. There are 862 delegates this year. That's down 2 from the 2016 General Conference, but with some shifting in numbers of delegates from various regions. You may be concerned with constitutional amendments and what those look like and how they occur. This is relevant to your work. To the extent that any legislation changing the structure of the United Methodist Church becomes a question, a constitutional amendment would be required. I know that you have heard today the plan presenters talk about our plan does not require a constitutional amendment. I think I heard all of them say that. That's an important point that they put forth because of the timing that is involved in constitutional amendments. But I want you to be aware that if there is a change that does require a constitutional change, then a constitutional amendment is the only way that you can get that accomplished. It requires a 2/3 majority vote at General Conference. It must be ratified by at least 2/3 of the combined voting members at subsequent annual conference sessions, and then it also entails a canvassing and vote by the Council of Bishops. Disaffiliation, which Brian Mills is going to talk about in more related to the trust clause, because there is a disaffiliation component within that context, but I'm going to flesh out the disaffiliation requirements under 2553. It must be based on reasons of conscience relating to a change in the Book of Discipline related to the practice of homosexuality. Now, depending on what General Conference does, I understand from reading the 8-page protocol agreement, I have not read the proposed legislation that is being drafted. I don't have any knowledge to share with you on that point, but I have read the 8-page document, the protocol document, and it intends to come to vote for you right out of the gate. If you've read it, you know that that is the intention of it. So some of these things that we're talking about right now, disaffiliation, for example, may not end up being relevant to you depending on how that occurs. However, we don't know yet what will happen, do we? So the way that this looks, the 2553 is the snapshot of what exists right now, this disaffiliation way to change membership. The district superintendent calls for a church conference. If the church conference votes to disaffiliate with a 2/3 majority, terms of the disaffiliation will be established by the conference board of trustees with the advice of the cabinet, the treasurer, the benefits officer, the director of connectional ministries, and the chancellor. GCFA shall develop a standard disaffiliation agreement that recognizes the validity of the trust clause, and Brian Mills has told me that it has already been developed and that all of the annual conferences already have that disaffiliation agreement from GCFA. The local church pays unpaid apportionments for the 12 months prior to the disaffiliation and an additional 12 months of apportionments. The local church can retain its property. The local church pays its pro rata liability of the unfunded pension obligations of annual conference, and the local church pays its own debts and liabilities or transfers them to its new entity. And disaffiliation must be complete under 2553 by December 31st, 2023. Now, Judicial Council authority at General Conference, they can determine the constitutionality of any act of General Conference upon appeal by a majority of the Council of Bishops or 1/5 of the members of General Conference. All decisions of the Judicial Council are final. When the Judicial Council declares any act of the General Conference unconstitutional while General Conference is still in session, they must immediately report back their decision and their ruling. And it's important to note that the Judicial Council can issue rulings ahead of time on constitutionality of proposed legislation. Now, the way that the advisory opinion or the declaratory opinion can change is if the legislation itself changes. So it's only as good as what ends up being passed. And sometimes there are other matters that come to the attention of the Judicial Council. They would be very candidly, I'm sure, to say that as various opinions develop, various legal considerations develop, then other applications of law become apparent that were not apparent before. So that is sometimes the way that the Judicial Council ends up changing or morphing decisions that have previously been made, and that can occur as well, especially in the context of advisory opinions or opinions prior to General Conference that are to rule on General Conference legislation. So I want to wish you the best of success at General Conference 2020. It's a big job that you do, and I want you to know that the chancellors very much appreciate all the attention that you give to the jobs and the voting that you will do at General Conference. Thank you.
So we've started down the rabbit hole of trust clause issues, and we need someone to lead us into that rabbit hole. Someone from GCFA. Come on, Brian.
Good afternoon, everyone. That's the appropriate level of enthusiasm. I appreciate you setting the bar low for me, so maybe that I can meet it. Yes, I'm Brian Mills, Interim General Counsel at GCFA. My view of my few minutes up here is essentially this. You've heard a lot of conversations and a lot of information about various plans throughout the day. There's a lot of complexity in a lot of these, and what I'm going to try and do for you is to give you some things that are kind of, for lack of a better term, the status quo. What's the arrangement right now as you potentially, as delegates in a few months, talk about how you might change that arrangement? I'm hoping that will be helpful, and I know we got a question period at the end. If something I say is not clear, yell at me at that point. So we get a lot of questions at GCFA about the trust clause. What does it cover? What doesn't it cover? The discipline is kind of like a book of laws, and so it's written in a way that is familiar to lawyers. So we say a lot of words, and what what the discipline means in all of those words is that all is all. You can see here, all properties of United Methodist local churches and other entities are held in trust for the benefit of the denomination. Down there, I mentioned for you that it's irrevocable. What that means is it's permanent. A local church or an annual conference or a general agency or a jurisdiction or a district or whatever it might be, it doesn't have the ability to turn that off. And we'll get to maybe some exceptions to that here near the end. Again, all really does mean all, and this is where we get kind of lawyerly, where we could have just said everything. But real and personable, tangible, intangible property held at jurisdictional, etc. That means at the local church level, lots of folks think about the actual building and the land that the building sits on, but it's not just that. It's the cash, it's the paper clips, it's the pews, it's the hymnals, it's the church bus, it's the investment account at Merrill Lynch, it's everything. 2501 makes it clear that it applies to all assets at all levels of the denomination. That sometimes I think is a little surprising to folks because again, there's a lot of thought and focus on the actual real estate and those types of things, but it is broader than that, and it is not just at the local church level. A general agency is just as much subject to the trust interests of the denomination as a local church is. You can see, continuing in 2501, that this goes back a long time. The discipline says that the trust requirement is an essential element of the historic polity of the United Methodist Church. It reflects its connectional structure, and it's a fundamental expression of United Methodism. Done this presentation many times for many different contexts and many different groups. And this is a slide that I always put in there. It's a little bit of background, but to me, it's a good way to understand that as United Methodists, our trust clause and our trust provision is different than some others. You can see the last year down there at the bottom that it was first published in the discipline in 1797. If any of you pay attention to trust clause litigation in the United States outside of the United Methodist Church, and if you fall into that category, my condolences. You've probably seen some issues the Episcopal Church has had, and they have won some and they have lost some from the denominational standpoint. By way of comparison, the Dennis Canon, which is the Episcopal Church's quote-unquote trust clause, was added in 1979. So we're talking about an almost 200-year difference in age. When folks say the trust clause, I think most times this is the paragraph that they're actually talking about. 2501 is a broad language about the denomination's trust interest in all property. And then 2503 kind of gets down to brass tacks as it relates to primarily local church property and puts out specific language that's supposed to be included in deeds. This is one example from 2503 as it relates to a place of divine worship. That's not the only version of the trust clause. There's one if it's for a parsonage. There's another one if it's going to be not just for one or the other. And then there's a third one for a property acquired from another United Methodist entity. That second long bullet with the sub-bullets there is from 2503.6. In essence, what that says is, okay, the discipline has just said what you're supposed to have in your deed. But if you don't, if it's not there, it's going to be read as if it's present if any or all of these following things apply. And I think a short summary of what those following things are is a way of saying if you're a United Methodist Church. Right? You're accepting appointments. You're using the Cross and Flame. You're using United Methodist in your name. You got your property from another United Methodist Church or a predecessor of the United Methodist Church. Shifting gears a little bit, There's the question of, well, can it ever be released? The short answer is yes, in certain circumstances. 2501.2, going back to that paragraph, says property can be released from the trust, transferred free of the trust, etc., only to the extent authority is given by the discipline. And the discipline does that in a couple ways right now. Do I have any district superintendents in the house? Okay, if you're right-handed, put up your right hand. If you're left-handed, put up your left hand. I have a former colleague in the legal department at GCFA said that the hands you're looking at right now are the most powerful hands in the United Methodist Church. And that's because the district superintendent is the only individual in the United Methodist Church, per the Book of Discipline, whose signature releases the trust clause. So in the case of a sale of a local church property, for example, it has to be approved by the pastor, it has to be approved by the district superintendent, and the discipline goes on to say that the district superintendent's signature approving the sale releases that property from application of the trust clause. And by the way, if it's not a sale, it's a mortgage, that same signature by the district superintendent approving the mortgage subordinates the trust clause to the mortgage interest of the bank. So to say all of that a different way, if you're talking about annual conference property, there's not that type of equivalent provision. There's processes still in place for getting approvals of selling annual conference property or district property or even general agency property, but there's not that specific sentence that says the signature of this person constitutes a release of the trust clause. And then, of course, as Pam mentioned, within the last year, there's one other avenue by which the trust clause could be released. That is going through the process of 2553. As I'm sure many of you know, at this point, and as Pam explained, it's limited in scope, it's limited in duration. Finally, the last question that I thought you might be thinking about is, well, is this enforceable? And I won't go full lawyer mode on you and bore you with the details of all of these cases, but I wanted to provide you with a couple recent United Methodist specific examples to illustrate that, yes, by and large, courts in the United States recognize the existence of the United Methodist denomination's trust interest in its property. I've picked a selection here of recent cases from several different annual conferences. They all have different fact patterns. Sometimes there is there's trust clause language in a deed. Sometimes there isn't. Sometimes there's a state statute that reflects what's in the discipline. Sometimes there isn't. But in all four, and here's two more, in all four of these, in our polity, it's the annual conference that is typically representing the denomination's interest in these lawsuits, has convinced the court to recognize the existence of the trust clause in its application to local church property. Thank you.
So what was the first legislation enacted by the 2019 General Conference concerning? Pensions. Andrew.
And on that note, Wespath is primarily a servant to this church. It's amenable to the General Conference. It was created to work through complex issues related to something that supports people's everyday lives. We take that very seriously. We take that very humbly. We spend most of our time trying to navigate the legal waters of where pensions and investing meet federal and state law and regulation, and we do that on your behalf. I spend most nights thinking about SEC regulations and IRS regulations, and I know probably most of you say, well, I could do that for myself, but we really take that on as our charge for this church. Pensions are intertwined intricately with federal laws and regulations as are investments, but the pensions of the church for clergy are very intertwined with church law as well. The U.S. clergy pension plans are distinctively connectional. The Judicial Council has said so. The General Conference has purview over them. That's why we talk about it with you once every 4 years. We talk about it in between times too, but we talk about it with delegates once every 4 years. Only the General Conference can change the clergy pension plans. Importantly, the overseas pension plans, the pension plans for central conferences, are governed locally. The General Conference does not have to really think about those plans. The central conferences can design them to their own capacity and their own context, and that's an important distinction. The clergy pension plans in the U.S. are also a legal obligation of the annual conference, and they aren't a simple one. They're a complex one, and they're an incredibly long-term one. I think this image is one of the images that went on Facebook around the world, but even if no one entered the plan from today forward, we will be paying pensioners until nearly the next century. So annual conferences have that obligation, and they manage that obligation through the support of the local churches in their geographic area. So as the church has gone through this impasse, we have done our part as best we can to support the church in thinking creatively about scenarios and contingencies and how to manage the risks that face the pension plans as the church has its dialogue. It's actually been, I guess, a blessing for me. I think I'm secretly a creative type trapped in a lawyer's body. You probably can tell that from the way I dress, but nevertheless, we've spent time thinking through these things primarily through the lens, as Barbara mentioned earlier today, of protecting the benefits for those people who depend on them to live day to day, and for those people who are depending on them in the future to have security in their retirement. And that's very important. We also think through how we can mitigate risks to the plan sponsors, i.e. the annual conferences, and help them navigate these waters as well. In 2019, the General Conference was facing proposals from the Commission on the Way Forward, proposals from other parties that were creative, were different, would have impacted the ability of conferences and churches to support those long-term obligations. So 2 provisions that were just mentioned were passed at the General Conference to manage these risks. They were designed for small-scale departures of local churches and clergy who were maybe tired of the debate or didn't appreciate the traditional plan that was passed, or might not have appreciated a different plan that was passed. We were planning through those scenarios to protect the pension plans by saying, if a local church departs, it should pay a withdrawal liability to its annual conference. If a clergy person departs, his or her benefit will be paid out in a different way. Those were approved by the General Conference 2019, but as the dialogue continued, we continued our contingency planning. We stayed in communication regularly with the stakeholders who were behind a lot of the ideation at the 2019 General Conference, and afterwards, we did the best we could to be there in a supportive and consultative role, not to support any particular outcome or any particular plan over the other, but there to help those people who were approaching solutions with all the best intentions to navigate mitigating risks to the pension plans and helping them come up with plans that didn't do harm to those pension plans. We also were blessed with that candor from these groups, so we learned a lot about what the thinking might be and what the church or churches might look like in the future. And it gave us a chance to creatively craft one of our own proposals that's in the ADCA It's a new paragraph of the discipline, paragraph 2555, and it would handle pensions differently than St. Louis. It would do it differently. Essentially, if a group of local churches or even an annual conference is changing its relationship with the United Methodist Church to form or join a new Methodist expression, and you heard about all the different variations on those proposals this morning, if groups are going to do that, we can handle the pension plans differently. As long as the group agrees to be legally responsible for them, to take on that long tail of risk, that long tail of obligation, and take care of the people that are going with them, we can divide the pension plans and manage a legacy plan for that group and a plan for the legacy UMC. We can do that. The new group has to also be viable. What that means is they have to have a corporate or some kind of organizational structure that governs the plans and that they can interrelate with us to give us the information we need, make the contributions that are required, and get information to the people that have gone with them. That's what that means. If that group can do this, what we would do we would take assets and liabilities associated with the people who have gone to join that group, the clergy, the retirees, the survivors that go with that group. We will take assets and liabilities that are associated with those people and put them in a new plan. Looks just like the clergy plan that exists today, but is separated from it. No longer has the connectional support of the rest of the UMC, but it has most likely some kind of critical mass, and it has a support mechanism in that new denomination. If those terms are met, the St. Louis provisions don't apply, and this new path forward makes some space for creative ways to move the church forward. In addition, we've postured ourselves to serve a new expression with other voluntary plans for healthcare and disability and death benefits designed for their capacity and their new polity. And that's what we hope to do. Now, this is all not magic. It's all not without any risks. The plans have been here a long time. That whole tail of long-term obligation has been funded, assuming the United Methodist Church, as it existed since 1968, was a long-term, ongoing concern. That's how we estimated returns. That's how we collected contributions from the annual conferences, based on that assumption. And that's part of the reason why the St. Louis provisions were passed, to protect those set of assumptions from the risk of small-scale departures. In bigger disruption, where we're dividing plans into multiple pieces, and both pieces are smaller scale, you introduce some risk. So it's not risk-free, what we're doing. I just need to get that out there. It's a good thing for the church to be able to get past this impasse, and we have done our very best to get the pension 800-pound gorilla out of the way so the church can become what it needs to be. But in any case, discontinuity in that tail brings some risk. So we have to be forthright. The other very important thing is, for the future, we need to close these plans, and you're going to hear about this tomorrow in a proposal for at least the post-separation United Methodist Church, or whatever that becomes, or the whole United Methodist Church if we stay together, to move to a new and different account balance defined contribution plan, like a 401k plan. That's important for the future, so we don't keep adding to the end of that tail for the future, because the United Methodist Church is going to be different, most likely, in any event. Lastly, as I mentioned, we stayed in dialogue with a lot of the stakeholders that have done the work that you heard about this morning, and we appreciated their candor, we appreciated their trust. We did the best to advise them as best we could, and we created that proposal that I just walked through, that new paragraph 2555, to be essentially a snap-on amendment to almost any of those plans. And that's kind of the way it's worked out. I think the most recent version, the protocol legislation, incorporates the same framework, the same sort of proposal to navigate the future for the benefit plans. And that's what I have.
We have about 5.5 minutes for questions, so if you have a question for any of our presenters, please move to one of the microphones, and we ask that you state your name and your affiliation and whom you wish to address.
Thank you. Fred Brewington, New York Annual Conference. Brian, perhaps this question is for you. If you could, you did talk about the trust clause within the context of the current Book of Discipline, but also if you could just address that for our brothers and sisters in the central conferences and the trust clause applicability in areas where the issues of property, both real and personal, may not be the same as they are in the United States.
Thank you, Fred. I think maybe. I'll say this about what the discipline says, and more specifically what it doesn't say. If you read 2501, nowhere does it say only in the U.S. So again, when it says all, it means all. I gave you cases in the United States that we're aware of. I am not personally aware of any in countries outside of the United States that have dealt with these issues. When you talk about different countries, sometimes you talk about different legal systems altogether. I do believe that there have been some similar types of issues. One comes to mind in the Philippines, and one comes to mind in a country in Africa where there was at best some confusion about who's an official representative of the United Methodist Church for that country, and the ability for some subgroup in another instance to essentially break away from the denomination in that country. And off the top of my head, I don't remember exactly how both of those were resolved, but there were arguments to be made even in some of these other countries that there is a denominational structure here that should be recognized and that the courts in the countries should follow.
We have another question.
Wasn't the question I was asking. For instance, there are contextually in many countries, property is not owned by the church. Property may be owned by the government. And with regard to the impact of the trust clause in those situations, currently the rewrite of the Book of Discipline seeks to address that in terms of adaptability. And I just wanted to raise that for the body so we understand that even though it says all, there are many places where it is impossible, legal impossibility for it to apply, and how important it is for us as a church to realize that.
Right, and thank you. And that is one aspect of the ongoing work of the Global Book of Discipline. My understanding of the sections of the discipline that are adaptable right now to central conferences do not include the property sections of the Book of Discipline. So it is certainly possible that in some countries outside of the United States where there are United Methodists, they have a version of the Book of Discipline that doesn't necessarily make sense to what their legal structures and ownership structures are.
Jay Brim, lay delegate and serving as chancellor of the Rio, Texas Conference, and I don't have a question. I just want to say to Brian and Andy, in front of all of the delegates here, thank you for the effort and time y'all have put in to help us all do our jobs out here, and you are great examples of the connectional nature of our church and the value of the general church to all of us at the local and conference level. Thank you so much.
Lonnie Chafin, Northern Illinois Conference. I have a constitutional amendment question. So if General Conference passes a constitutional amendment by 2/3, it then goes to the annual conferences for a vote. What if an annual conference then votes to leave? Will those tallies be counted against the vote for acceptance of the constitutional amendment?
I don't know. So I got a kick out of how we're described as legal experts, and you'd like for us to be that, but I think what we need now are experts in change, because we are in such a state of transition, and your question stretches beyond what I know how it will play out. I don't know the answer to that.
Last question.
Jessica Vittorio, the North Texas Conference. I had a quick question, and it's primarily about the trust clause. I'm hoping it's not too challenging for the end of the day, but so there are situations in which the DS can be the one to sign away or waive rights under the trust clause. What fiduciary obligations is an individual acting in that capacity bound to?
This is when I'd like to call on the DS to come up here and give their point of view. I'll try and answer it this way. Typically, when I have more time to talk about the trust clause to smaller groups, I get into a section kind of what I call the trust clause in action, which is primarily you see later in the 2500s, there are a series of paragraphs about local church property, specific procedures to buy, sell, lease, transfer, mortgage local church real estate. And you'll see make sure there's approval of the church, make sure that the pastor's on board, make sure that the district superintendent is on board. And my personal view of that layer of the district superintendent is that person is kind of standing in on behalf of the denomination because that trust is being held, or that property is being held in trust for the benefit of the denomination of a whole. And usually what benefits that local church is going to line up with what benefits the denomination and making disciples. But let's say, for example, a church that's a couple years old wants to build a $9 million building, kind of on a, if we build it, they will come type of philosophy. That may not necessarily be a good idea. And the layer of the district superintendent on top of that, I think, is a way to kind of say, okay, well, let's think about this. Maybe from a larger polity standpoint, this is maybe not a good plan. Let's find some other option. And so maybe I'm not going to agree. So the flip side of that is a sale, and it's kind of the similar type of concept in reverse. Is what is the church's plan here? Are they selling and then going off and doing something that makes sense, or what is their plan to use these proceeds for? Is it something that makes sense? So I see that as kind of a bit of an analog for the denomination's kind of trust interest there. And none of this of what I'm saying is specifically in the discipline. It just says the DS either approves or the DS doesn't. And if the DS doesn't, then according to the discipline, the transaction's not supposed to happen. So that's kind of what makes sense to me with having that there without the discipline really kind of providing any context for the DS to make that decision one way or the other.
Last word to thank our panelists.